Let's see how many of you can identify with one of the categories that I'm going to discuss today. We are talking about options that are available for people who have come to the UK as skilled workers or who came as students, for whatever reasons have not been able to continue with their studies, or if they came as skilled workers, their companies have shut down or they're not able to give them enough work to be able to carry on under the rules as they're meant to be. Now, we all know what the pandemic the immigration pandemic is. Why I call it a pandemic? Because people started following a certain criteria or a certain success story and then went on and on blindly into it. It was blind leading the blind and people just went on for it. I've been talking about it for a couple of years where I've been saying that these skilled worker visas where you are getting into these contracts or you're getting into these skilled worker relationships with companies that are not genuine or that are not able to give you the work that you require are simply trying to make money off you, or the agents that are involved that get you those visas are simply making money out of you. So what's now started happening is, and I'm getting a lot of these clients now, a lot of these cases where people are stuck. They are frustrated. They don't know what to do. They've spent a large amount of money to get a sponsorship. They've spent a large amount of money and expended time and effort in order to get the skilled worker visa that they wanted. Now that they have it, they could be carers or they could be other visa categories. Now that they have them, they are not being offered the jobs, or they are being told that you need to work separately somewhere and make sure that you are paying your taxes so that your employment may continue. Now, I can tell you from experience of doing this for over 2 decades, these people are not going to get their indefinite leave like that, because it is not simply a matter of producing a P60 at the end of 5 years. You might be asked to produce other documentation such as your taxation records, your bank statements, or a lot of other stuff. I'm not going to go into all sorts of things that I get to hear that people are doing to get out of these scenarios, because some of them are absolute horror stories. But what I want to do is I want to give you some legal options today and see where you can do something to get out of this madness that you're stuck in. So the first thing I want to talk about, if you are an educated person, you're a skilled person, you can do something. What you can also do is you can form a company. You form a company or you get together with a partner who wants to create a company, wants to form a company where there will be a genuine vacancy for you. As long as there is a genuine vacancy, you can be sponsored by that company. So some people call it a self-sponsorship, some people call it whatever they want to call it. There is, if you try to do this on the Home Office website, I don't think you're going to get any hits on that, which shows you exactly how it works. The way things work are that there is a company that has been formed in the UK. The company can apply for a sponsorship license, get the sponsorship license, and that will only happen if the company is genuinely trading. So please understand, I am not giving you a get rich quick kind of tip here, or get out of jail card, or some sort of a fraudulent means, or some Ponzi scheme to get out of trouble. No, I am not doing that at all. What I'm saying is that the skilled worker rules say that if a company has been formed by you, for example, and you are not the level 1 user, or you're not one of the key personnel of that company, the company, being a legal identity by itself, can sponsor you if you have the right skills to do the job. So the company will get a sponsorship license and then be able to sponsor you. A lot of people want to do this. They don't understand how this works. And that's where the professionals come in. If you want to do this properly, speak to your accountant, speak to your business advisors, speak to your solicitors. You want to speak to us, we have our own business immigration department. And this is where we are dealing with these matters very clearly and cleanly. As long as you are able to prove and produce all the documentation that is to go with that. So if it is a company, the company must be trading, the company must have its bank account, it must have its own ledgers and whatever else we require. Everything will be put together, then put to the Home Office. The Home Office will come and visit and check and make sure that everything is correct, and only then issue the sponsorship license. And once you've got the sponsorship license, if you've got the right skills to be able to do that job, which is a genuine vacancy, then you can be sponsored by the company to do that. So this is one category you can look into. Another thing you can do is, and these are obviously fact dependent. So everything will depend on what your particular facts are. Some people are highly skilled, some people are highly qualified, some people have just a general knowledge of things and they are able to learn very quickly. So depending upon what your situation is, whether you can go into business immigration kind of things or not will obviously depend on your facts, on your case. Now, there are certain situations where this will not be an option for you. What will happen then? If you don't have a particular skill, or you're not able to open a company, or you're not able to be sponsored by a company, what do you do then? Then there could be an option of a human rights application or outside immigration rules application. These applications I've talked about many times as well. What are we doing with these applications? All we're doing is putting all your circumstances together, whatever difficulties you've had, whatever problems you've had, explain those. If you've not had any hand in getting into that difficult situation yourself and circumstances have just got you there, then of course that can be explained. So these are called the compassionate grounds applications or exceptional circumstances or human rights, whatever you want to call it. People call it all sorts of different names. I simply say this is an application done outside immigration rules, which acknowledges that you do not fall under any of the immigration rules, but given your circumstances, you should be looked at compassionately and probably granted status on a discretionary basis. So these applications can be done as well, and you can do fee waivers as well if you qualify. What is a fee waiver? A fee waiver is a request to the Home Office to give you a waiver or give you an exemption from paying the Home Office fees and the immigration health surcharge if you're unable to afford it. I know of families, husband, wife, and 3 kids, and they're on a skilled worker visa, and now they're starving. They have no money. The job is not paying them anything. They have no hours to go and work, and they are stuck. So if they were to do an application, that application has to be done to the Home Office with the correct fees. And if you're not able to pay the fees, then your application cannot be submitted unless you have been granted what we call a fee waiver. Of course, if you speak to me, I will give you the details of all these applications or how these are to be done, and we can do those for you. But right now, I'm just touching upon all these topics. So fee waivers can be done for this as well. Another common situation that I've faced, and that comes with financial stress and possibly all sorts of other problems that people face, young couples mostly, where they have come to the UK in order to create a life for themselves. And then they find themselves in these scandalous situations where their job is not paying them or they don't have enough number of hours, and they start getting into that financial stress, and which causes an emotional stress, and there are rising number of domestic violence cases in those situations. So I've taken on a number of cases in the last 6 months where things have got really bad, and it's not just limited to women suffering domestic violence. So please let me be very clear, there are men suffering domestic violence as well. And let me also be very clear that domestic violence does not mean that somebody's come home and taken off a belt and started beating you or something like that. Domestic violence is physical abuse, it's mental abuse, it's financial control, it's all sorts of things that can be utilized in order to control another person and to put them in a situation where they are not able to exercise their free will. All those things put together can be argued under domestic violence. What is most important is that you report these matters either to the police or to your medical professionals or your social workers, whoever is close to you, whoever can help you. Make sure that you reach out and ask for that help, because unless you do so, you will not have any documentary evidence of what you're saying. It's going to be, your word against the other person's word. And a lot of times people suffer because they don't have any kind of evidence. Next category I have is the relationship or children basis. So these are people who are not in families altogether. These are people who have come as single people here. who knows what your immigration status was before, but right now you are in a situation where you are in a relationship either with a British national or with somebody holding leave to remain in the UK, or with somebody holding indefinite leave to remain in the UK, or settled status or pre-settled status or refugee status, whatever it is. Every category will have its own rules that we can then follow. Now, what happens when you're in a genuine and subsisting relationship? And the rules on the relationship definition have changed recently as well. So previously, it used to be that you had to provide documentary evidence of at least 2 years of cohabitation as husband and wife, or whatever you want to call it, as unmarried partners. So now the rule has changed in the sense that even if you do not have documentary evidence will be what? Bank statements, your pay slips, your bills in your names, tenancy agreements in your names, things like that. Even if you do not have things like that, you can still qualify by proving the existence of a genuine and subsisting relationship. And that can be done by text messages, by photographs, by witness statements, by letters of support. All sorts of things can be brought into that as well. So I would say look into that if you are in that situation. If you've had a child in the UK, especially if that child is a British national or has got some sort of leave in the UK and you're not with the partner, or if you're with the partner, again, depending upon what the situation is, you can either go for a relationship-based application or a parent route kind of application. It could be on a 5-year route to settlement or a 10-year route to settlement. Depends on your particular facts. All these things put together, there are still options available. And I really hope that we can find some for you. Thank you very much for listening.